morning, everyone. My name is John Cornwell, and I'm the Director of Practice Development here at Plunkett Cooney. I have the privilege of assisting with today's call, and we're going to cover the topic of sexual harassment in the workplace. We're joined today by two members of Plunkett Cooney's Governmental Law and Labor and Employment Law practice groups, Michael Hanchett and Reagan Glenn, both of whom practice in our Bloomfield Hills, Michigan office. Before we get started, though, I'd like to take a few moments to provide you with some background about today's speakers and about our law firm. For those who don't know, Plunkett Cooney is based in Southeast Michigan and is one of the Midwest's oldest and most accomplished law firms with approximately 120 lawyers. We have offices in 8 Michigan cities, as well as in Chicago, Illinois, Indianapolis, Indiana, and Columbus, Ohio. Our governmental law and labor and employment law practice groups include more than 25 attorneys who work in the areas of municipal law, traditional labor law, human resources consulting, investigations and employment litigation, and other areas that would be of use to you as employers that are attending today. Our webinar has been approved for one general recertification credit hour through the HR Certification Institute. That's hard always for me to say, HRCI, and one professional development credit through SHRM. Following today's program, a certificate of completion will be emailed to each of you, reflecting the credit. But if you don't need any kind of CE credit, you can just simply disregard that email and that certificate. Now, a little bit more about today's presenters. Happy to let you know that for a decade now, Michael Hanchett has been defending municipalities and employers in work-related litigation, including claims of sexual harassment. He routinely advises employers and HR professionals on all areas of employment liability. He's the recipient of several legal industry honors, and he's licensed to practice in Michigan state and federal courts. Reagan Glenn is an associate who works with municipalities on a range of legal issues, including employment-related disputes. Her practice also includes the defense of private sector employers directly and through their insurance providers when they become entangled in related litigation in Michigan's state and federal courts. Just a couple of housekeeping notes about today's program. For the Q&A portion, we're going to use the questions tool on your GoToWebinar dashboard. It's up there on the top right as well. It's got a little question mark in it. So take a moment now, if you could, to locate that. And at the end of the presentation, we're going to try to answer as many questions as possible. And I always add a caveat to this point. If when asking your questions, just kind of keep it general if you could. We don't want you to provide too much information that would divulge, the name of your company or municipality or any details about your specific situation unnecessarily, and we would hope you would agree with that. Finally, I want to mention that today's session is being recorded, and that recording is going to be available a little later today, hopefully on Plunkett Cooney's website, which is located at plunkettcooney.com. So you can feel free to share a link or direct your colleagues to that page, or if you wanted to listen to a portion again, you could do that at your convenience. So thanks again for attending the webinar. Now let's get things started. Mike, I believe you are kicking things off, so please take it away.
Yeah, thanks, John, and thanks everybody for being here today. As John mentioned, myself and Reagan, most of our practice is representing municipalities. However, we are seeing an increasing number of employment lawsuits that are coming in, especially in the sexual harassment area. So we felt like this was a pretty timely presentation. We really don't have too much time today, of course. We've only got a little under an hour. So we really want to hit on some of the high points. And our goal is to give you the resources to set yourself and your team up for success in this area. Anything we can do to help expand upon these specific points, please just let us know. A few key takeaways from today. One, don't touch your coworkers. It sounds like a joke, but it's serious. Don't touch your coworkers, no matter what. It's always a good rule. The second one, don't date your coworkers. I think it goes without saying, but we'll get into some of the specifics of that later on. And number three, when in doubt, do the opposite of what Michael Scott from The Office would do. Whenever you watch that show, I'm sure a lot of us have watched it. Anything that he's doing, do the opposite. So I'm going to pass this over to Reagan now at this point. Reagan's going to get into some of the specifics about the areas of law and some of the statutes to be aware of.
Thank you, John, and thank you, Mike. We have a lot of content for you today, so I'm just going to jump right in. In Michigan, we have a law called the Elliott-Larsen Civil Rights Act. You may have heard or seen this referred to as ELCRA, E-L-C-R-A. ELCRA prohibits discrimination in a variety of settings, including the workplace, based on a person's membership in a protected class. Now, we have the protected classes listed for you on the screen. Includes religion, race, color, age, and we're here today to talk about sex. As a note, protected classes have been expanded recently in March of 2023 to include sexual orientation and gender identity or expression. This is relatively recent and kind of indicates that we could potentially see this expanding again in the future. So, looking ahead, what is sexual harassment? ELCRA says that discrimination because of sex includes sexual harassment. So this can essentially take one of two forms, and that's physical and non-physical. When we think of physical, there's the obvious, red lights are flashing, this is physical sexual harassment, but this can also be, those friendly or innocently intended touchings where it is unwelcome and a reasonable person would view it as offensive or inappropriate. We sometimes see this manifesting as, that friendly shoulder rub or touch on the leg. These are difficult to defend on emotion because these boil down to factual questions of whether or not a reasonable person would view it as offensive or inappropriate, even when the person that is doing the touching may not intend for it to be, sexual in nature. And then we also have non-physical, which most of our presentation is going to touch on today. So getting right into ELCRA, sexual harassment means those unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct or communication under the following circumstances. So the first is submission to the conduct or communication made a term or condition. This is your quid pro quo, this for that. If you go out with me, I'll make sure you get promoted or get that raise or get that bonus, whatever it may be. This is the promise. Looking ahead, we have where the submission to or rejection of the conduct or communication is used as a factor in decisions. So this is where there's a tangible reward or punishment. If advances are rejected, there's some sort of demotion or other punishment that the employee receives, or where the employee goes along with it, they receive, some sort of benefit. So this is the tangible effect of their response to whatever the advance may be. And then we also have where the conduct or communication has the purpose or effect of substantially interfering with the individual's employment or creating intimidating, hostile, or offensive employment. This is your hostile work environment, and we're going to spend some time, delving into what it means for a work environment to be hostile. So it's important to note that sexual harassment is not conduct that is instigated or initiated or inflamed by an employee. This is unwelcome, not solicited, regarded as undesirable and offensive. We had a case relatively recently where a female employee had filed a lawsuit claiming sexual harassment and included pages and pages of these direct quotes of things that had been said to her or things that had happened during her employment. We were astounded. So we met with everybody in her department, and every single person said the same exact thing, that this employee was starting this behavior. These jokes that she was now complaining about in her lawsuit are ones that she had initiated, started, and really got the ball rolling on it. So, sexual harassment isn't something that, you invite or seek out. This is something that is not solicited, and it's unwelcome. So we have some examples of offensive language or conduct. I'm sure that you can all think of several that you've either seen firsthand or on television or in the news or what have you. The main crux here is that these are things that someone wouldn't do or say to a member of the other sex. And we often see it manifesting as, a man saying it to a woman or a woman saying it to a man. This can also occur where, a man is engaging in this conduct towards a man, but he wouldn't have engaged in this conduct towards a woman, and vice versa. So, this can be, the actual comments that are said, and other actions. And there was an interesting case where some employees were posting comics and pictures in this other employee's cubicle. That is definitely sexual harassment. So it doesn't have to just be something that is said. It can manifest in those other ways too. And I just want to make this important distinction here. This is not confined to what goes on in your workplace during your business hours. The sexual harassment can occur in other venues too. So when employees get sent out to conferences or seminars, or the company holiday party, what have you, these are environments that sexual harassment can arise, and that your entity can ultimately be held liable for. Getting into the quid pro quo, again, like I said, it literally means that for this. This can be, subtle or not subtle requests for sexual favors. And again, it can manifest in those tangible employment actions, or, either punishment or reward, depending on how the employee reacts or receives any advances. So getting right into hostile work environment. This occurs when there's some action that unreasonably interferes with someone's work performance. So in order for this to happen, the actions have to be sufficiently severe or pervasive. And we're going to get into that. But this conduct has to have the effect of creating an intimidating, hostile, or offensive workplace. So severe or pervasive, what does that mean? That is the repetitive, constant, nonstop comments, jokes, postings, that somebody is making to another employee. There's a really good example of that. Every single day, this woman walked in through the front door and had to walk by a male that was seated near the front door. And every day he had a comment about, her physical appearance, how her jeans looked on her, what have you. I just want to make a distinction that these are not the, nice haircut comments. These are very sexually explicit, sexual in nature, and it was constant, it was nonstop. This female employee, became so uncomfortable, so offended by these comments and this conduct, that she started walking around the building to go in through the back door just to avoid this employee's daily comments. So when we talk about severe and pervasive, I mean, it has to be severe, and it needs to be something that is happening very frequently. Now, maybe an employee doesn't necessarily interact with that harassing employee every day based on their job duties. It can still be severe or pervasive conduct, even if it's, not necessarily frequent interactions, but every time that employee is interacting with that person, there's some sort of inappropriate conduct that's happening. And just touching a little bit on the intent, the harasser doesn't have to have the intent to harass. I was just joking, is not a defense in these cases. That's not an excuse. So looking forward, this is conduct that is severe and pervasive. So, those stray, isolated comments or jokes that are, maybe not appropriate or made in bad taste, that's not actionable. It has to be something that is constant, severe, pervasive, and that ultimately interferes with someone's work performance. So, Mike and I, we don't want people to leave this presentation today and scrub everyone's personalities. That is certainly not the message. So, those stray isolated comments, not actionable, but when it reaches to the level that it's severe and pervasive and that people are having to, deal with this, and it's causing interferences with their work performance, that's where we see a sexual harassment claim. So in order for a plaintiff to establish a claim of hostile work environment, they have to demonstrate that they belong to a protected class, that they were subject to unwelcome communication or conduct based on their protected class, here their sex. The unwelcome conduct or communication is intended to or has the effect of interfering substantially with the employee's employment, creating this intimidating, hostile, or offensive work environment. And that but for the fact of his or her sex, they would not have been subject to that harassment. Again, so it has to be based on their particular sex. So, I mean, how do we make this determination whether it rises to the level of hostile work environment or not? Well, it's a fact-based question. In terms of a physical touching, it only takes one touching. That's sufficient to establish a hostile work environment and sexual harassment. But what about when it's this conduct and it's these comments? We look at the frequency. How severe, how pervasive is it? We evaluate the things that are being said, whether they're physically threatening, embarrassing, humiliating, or whether they're just, the mistaken, distasteful, stray jokes or comments that may be made in the workplace. Again, it really has to rise to that level of severe and pervasive. And then again, we look at how it interferes with the employee's work performance. Is their performance plateauing? Are they missing work? And plaintiffs can also establish this, by presenting that they've been emotionally affected. That would satisfy, whether it unreasonably interferes with an employee's work performance. It doesn't necessarily just have to be their work performance numbers that may be reflected in company numbers. This can also be, mentally and emotionally affecting this employee too. I'm going to turn it over to Mike now.
Okay. And looking at this, I think an important distinction to make here, I know looking at our list, we've got a lot of supervisors and managers who are on this, the webinar today. As a supervisor and manager, you really are held to a different standard than your other employees. What might be okay for employees to discuss, little bit of flirting, asking another employee out on a date. While it might be inappropriate, it might not rise to the level of actually creating a hostile work environment or being sexual harassment. On the other hand, it's never okay for a manager to flirt with a lower level employee, attempt to pursue a relationship. You have to realize, from a practical standpoint, as a supervisor and a manager, you're the one that's making the overarching decisions regarding this individual's employment, whether it's staffing, schedules, assignments, promotions, demotions, compensation. That's coming from you. And so you want to make sure that any actions or inactions that you're taking are shown as unbiased and not based on any personal relationship with the individual. Any other implications of a sexual nature or favoritism towards a particular employee, such as a female employee that a manager is pursuing. We see cases like this all the time where an individual gets a promotion and everybody thinks it's because the two of them have a relationship together. You want to completely scrub any, while Reagan said earlier, we don't want to, completely scrub any personalities. Really, we want to scrub any relationships between managers and the employees that they manage. Any other implications could open yourself and your employers up to liability, which we'll talk about in a second. We see this a lot in cases where a relationship starts, everything's going great. An example we have, a case we had recently, it was a lieutenant in a police department who was dating one of the patrol officers. Everybody knew about it. Everything was going great. You know, it was, you know, they were in the honeymoon stage. Everything was great in paradise. And then, of course, it wasn't. The two of them went through a nasty breakup, and there was a lot of emotions. They had to see each other every day. The lieutenant was still the female patrol officer's boss. Eventually, she filed a lawsuit making the claim that the only reason that she went along with dating the lieutenant was because she felt like she had to. She felt like she didn't have a choice. He pursued her initially, and she felt that because he was her boss, she couldn't say no. Whether or not this is true for the lieutenant, his intentions, as Reagan said earlier, are irrelevant. It's what that employee felt. So again, getting back to our previous point, don't date your coworkers. Specifically, if you're a manager, if you're in a supervisory position, do not date, flirt with your subordinate employees. Going on to the reasonable person standard, when we look at this reasonable person, who is this reasonable person? We hear about this a lot in employment cases. We hear about it a lot in our excessive force cases with police officers. There's this hypothetical reasonable person. You can see here on the screen, you know, looking at a hostile work environment, whether a reasonable person in the totality of the circumstances would have perceived the conduct at issue as substantially interfering with the plaintiff's employment or having the purpose or effect of creating an intimidating, hostile, or offensive employment environment. This reasonable person, they're not a perfect person, but it's really also not a person that makes many mistakes. It's not anybody on, you know, any of us on this call. We all make mistakes, but this hypothetical reasonable person, you know, we look at the totality of the circumstances, all the evidence that was going on at the time, who was present for when this sexual comment was made, who was it directed to, how many other times, looking at this, the frequency, how many other times did this person, you know, make these comments. The problem that we run into, though, when we're litigating these cases is the reasonable person is usually a question that's determined by a jury. A judge can't make define questions of fact. So whether or not a reasonable person would have found that the conduct was hostile, intimidating, that's going to be up to a jury of our peers. Who's on a jury? It's going to be your mom, your grandma, your sister, your cousin, maybe even your daughter, making a determination as to whether or not what you said substantially interfered with the person's employment or created an intimidating, hostile, or offensive environment. When in doubt, we always say use the grandma theory. Would your grandma find this to be offensive? Would she find this to be intimidating? Also, if she would, don't say it, don't do it. Also think about your spouse, your son, your daughter. Would you want somebody at their employment talking to them like this, touching them in this way? If you would say no, don't do it yourself. Stay away from it. That will help you move towards the reasonable person standard. Moving on to a couple of examples. We've changed the facts of these around, the names a little bit, but these are real cases that we've had recently in the past. Looking at the facts of this one, over the course of 6 months, a female firefighter, Officer Chen, is subject to the following in the firehouse. Male coworkers post sexually explicit photographs in the common area. They routinely comment on her appearance and make remarks about women not belonging in fire service. And one coworker once blocked the bathroom door until she pushed past. Officer Chen has not formally complained because she fears about being labeled a troublemaker. Again, this is an actual case that we had where they were blocking this female employee from using the bathroom at the firehouse. So what do we look at in this type of a case? First, again, we look at the frequency. This happened for 6 months. This wasn't just a one-off comment, one day where this occurred. The severity, obviously sexually explicit photographs have no place in the workplace. And the fact that they were blocking her from going to the bathroom. That was interfering with her work performance. It's also important that it was directed to a specific employee. It wasn't a comment that was made, a one-off comment that was made generally. It was directed specifically to this firefighter. So this is clear sexual harassment. Moving on to our next examples. As Reagan talked about earlier, mere utterances aren't enough. So we're looking at kind of where we draw the line in these cases. Looking at fact pattern number A, during a one-time staff luncheon, a coworker makes a single off-color joke with a sexual undertone. Several employees are visibly uncomfortable, but the comment is not directed to any individual, and it's never repeated. Looking at that one, again, this is inappropriate, but the fact that it was just a one-off comment, not directed at any specific person, likely doesn't rise to the level of sexual harassment. We're going to talk a little bit later in the presentation about responses to these issues. But here, we want to make sure that we're still addressing this with this employee. We want to make it known to them as well as anyone else in the department or the agency that this kind of conduct is not appropriate. It shouldn't be done again. Whether or not they might need additional training, that'll be based on a case-by-case basis, but still making sure that we're responding to this, even though doesn't rise to the level of sexual harassment. Fact pattern B, department manager routinely greets the sole employee engineer on his team each morning by commenting on what she is wearing, says things like, "You're too pretty to be an engineer," and makes frequent sexual innuendos at team meetings over the course of a year. Again, we have the frequency, repeated comments over the course of a year. It's directed at one single female employee, making comments specifically to a female employee that she's too pretty to be an engineer. This obviously rises to the level of sexual harassment. As Reagan pointed out earlier, this is consistent with a case that we had recently where the female employee took a different route into work because she was constantly being sexually harassed by another employee. So that's kind of helps a little bit on showing where we draw the line in this type of situation. Looking at a couple examples for the reasonable person standard. So the facts of this example: Dave, a city manager or a city employee, alleges that a female supervisor repeatedly comments about his physique and her practice of touching his shoulders each time she passes his desk creates a hostile work environment. The supervisor argues that her behavior was harmless and that she didn't mean anything by it. Dave found the conduct offensive and unwelcome. As we talked about earlier, the person who's accused of the sexual harassment, their intent is irrelevant. What they meant by the touching isn't irrelevant to the analysis. Again, we've got the frequency of repeated comments. This isn't just one comment that might be inappropriate. It's repeated comments and continuous touching. Again, don't touch your coworkers. We had another case recently, which was a little bit less egregious than this even. The employee, it was a very hectic day in their department. Everything seemed like it was going wrong. The male employee went over to another employee, put his hands on her shoulders in a chair, and kind of gave her like a light shake and said that, this is nuts, this is crazy, kind of indicating that, he was losing it. This was a crazy day. Again, that physical touch, that's where we're going to see, even if his intentions were just connecting with another employee, if that other employee felt uncomfortable, then it's not appropriate. And again, don't touch your coworkers. Moving on to employer liability. As you're aware, an employer can be held liable for a hostile environment, but what we look at here is what the employer did when it became aware of the sexual harassment, what the response was, what the supervisor manager's response was. There's really two requirements that the courts look at when assessing employer liability. It's whether the employee failed to take prompt action and the employee fails to adequately take adequate remedial measures. So that first piece, prompt action, if you're a supervisor or a manager, you learn of sexual harassment that's occurring, you need to step in immediately and stop it. Whether it's distancing the two people, telling the individual who's being accused of sexual harassment to stop, you don't make those comments, don't touch that female employee, whatever it may be, you need to take prompt action, not wait until after an investigation is completed, wait to see if there is any merit to the allegations. You need to step in immediately and stop the action to ensure that if it is occurring, it doesn't continue to occur. That second piece, taking adequate remedial action, what did the employer do in response to the sexual harassment? What actions were taken? What investigations were completed? Based on the severity of the sexual harassment, what is considered adequate will change. Obviously, in that example we had earlier where it was a one-off comment that was sexual in nature, first time the employee made that comment, might have just been a poor judgment on that person's part. That likely doesn't rise to the level of sexual harassment, but the individual, in that sense, needs to be told that this is not appropriate. Again, you might need to send them to additional training. And then as we progress into more serious, sexual harassment incidents, is a suspension warranted, termination, all the way up into referring the matter for criminal charges. If we have something, a sexual touching that is unwelcome, then that's obviously the worst it can get. Moving on now to the supervisor's liability. I talked a lot about what the supervisors need to do, but it's also important to note that if a supervisor does not take action and doesn't act on a specific complaint, you yourself can be held liable too. So if a lawsuit's filed, it's not only going to say ABC Corporation or the city, it's going to have your name as a defendant as well. So this is to protect you further as well. Moving on to the duty to report. Again, if you hear something, if you see something, you have to report it, no questions asked. Once an individual comes to you and complains of sexual harassment of any kind, you need to first, again, stop it, make sure it doesn't occur again to the best of your abilities. And then you also need to report it. We're going to talk a little bit later about having adequate policies that define specifically who you report it to and what actions you need to take. You need to make sure that you're following those policies. Make sure you're reporting it. If you're a mid-level manager, you're reporting it up the chain. Also, if an individual is complaining of sexual harassment against you specifically, you need to make sure that you're reporting it to the appropriate individuals. Failure by a manager or supervisor to both stop and report sexual harassment can result in discipline to that supervisor or manager, and it can also result in civil liability as well. Again, moving on further, this is the case even if an individual tells you. We see this a lot in our cases where an employee comes to you, they feel comfortable with you, thankfully, but they say, I wanted you to just be aware of this. Joe has been making these comments to me about the way that I dress. It makes me really uncomfortable. However, I don't want to be looked at as a person who's complaining or going to you with these issues. So don't say anything. I just want you to be aware of it. Unfortunately, it's too late. They've rung that bell. You have to report now, no matter what. No matter, it might cause some wrinkles, some issues between employees. It might cause, some issues with that employee who was reporting it to you. Once you receive a report, you have to move that report forward and properly report it, investigate it, depending on what level that you're at. This is the case even if the victim tells you that they don't want you to say anything. Moving on here, obviously this is a fine line between, being able to connect with your employees and making sure that they feel comfortable coming to you while also continuing to comply with your reporting requirements. As a manager or supervisor, you want to ensure that your employees feel comfortable coming to you with these issues. You want to make sure that you're receptive to taking these complaints and showing that you're going to do what's necessary to protect them, to ensure that the investigation is completed. And again, if one way to do this is if an individual comes to you with complaints about you specifically, you don't want to handle an investigation yourself. We do see this very often where, we've got a lieutenant or a chief of police who an individual comes to and complains about sexual harassment, and they handle the investigation themselves. When in doubt, refer it out to somebody or bring somebody else in from another department who has no connection to these employees, isn't in direct supervisory line to the chief or the lieutenant who can perform an independent investigation. And I'm going to pass it back over to Reagan to talk a little bit about retaliation.
Sorry, started talking before I was unmuted. Anyway, so it's important to note here that the statute of limitations for these claims is 3 years. Things change over 3 years. The makeup of your department or your company will change. The things that may have been acceptable or appropriate, as we've seen, can change rapidly over a 3-year period of time. Memories fade, people leave your company, so it's important to investigate these claims. That way we preserve the record, we preserve the evidence that we have. So once a claim is reported, how do we respond? Well, first, we hope that you can do some sort of internal investigation. The thing that we, stress you cannot do is retaliate against these employees. ELCRA explicitly prohibits retaliation or discrimination against the person because the person has opposed a violation of this act. That means that they opposed whatever discrimination they faced, either by filing a complaint, reporting it, filing, with the EEOC, or filing a lawsuit, or even participating in investigation. If an employee that's not complaining of having been harassed or discriminated against participates in an investigation, you cannot later then take some retaliatory action against them. That's explicitly prohibited by ELCRA. So, looking ahead, how do we establish that? How does an employee establish a retaliation claim? They have to establish that they engaged in a protected activity. That is, that they reported or complained or participated in this either investigation, or they reported or complained that they were experiencing this discrimination or this harassment. This has to be known to the defendant. Oftentimes we'll see where an EEOC charge is filed and the employee, has no clue and doesn't receive notice of it until, after the employee, is terminated or ultimately leaves. So the plaintiff has to show that the defendant knew. Oftentimes we'll see where the plaintiff will say, everyone knew that I was going to file this EEOC complaint because, I told everyone. Well, again, they have to show that the people that the defendant knew, that the people with decision-making power knew about this EEOC charge. And then they have to show that there was an employment action that was taken against them that was adverse. This isn't just being terminated or demoted. This is being put on the undesirable shifts, being given the undesirable tasks. Maybe that your office is moved or something like that. Those are all things that a plaintiff can use to establish some sort of adverse action was taken against them. And then there has to be this connection between that protected activity of reporting, complaining, or participating in this investigation. It has to be connected to the ultimate adverse action that was taken against them. When a complaint is made that an employee is being retaliated against, we like to see when an internal investigation's conducted by an outside source, because again, they can evaluate whether or not there was this actual connection between whatever the protected activity was and the ultimate action that was taken against them. So looking ahead, there's something called the cat's paw theory. Basically, this says that a harassing supervisor cannot influence another supervisor to engage in retaliatory conduct against the individual that reported or filed that claim or participated in that investigation. So, this isn't just the obvious circumstance or situation where, the harassing supervisor says, you owe me a favor or what have you. This can also be where that harassing supervisor is constantly reporting biased opinions or complaints against that employee that ultimately influences the other supervisor to take some sort of action against the employee. This is a little bit tricky. This is where that harassing supervisor is essentially, pawing over into this other department or this other supervisor's purview and making or influencing some sort of adverse action against the employee. Where the acting and supervisor bases their decision on grounds that are unrelated to the harassing supervisor's bias action, there's no liability. But again, that's something that needs to be established and articulated when the non-harassing supervisor makes some sort of determination. They have to be able to articulate the basics and the grounds on which their ultimate decision was based, aside from the harassing supervisor's influence. I'm going to turn it back over. Oh, maybe not. So what are some examples of retaliatory conduct? Again, this is where an employee is demoted or loses hours after a complaint is made. We oftentimes will see some sort of conduct happen in the workplace, and maybe people become alerted to, some sort of performance deficiency or what have you, and start, conducting these reviews. Employers need to be careful in doing that these performance reviews are consistent across the board, that they're not just against that complaining employee. And, we oftentimes will see this become a little bit of an issue where that employee has stellar, rated 5 out of 5 for years, and then some sort of incident happens and all of a sudden they get these poor performance reviews. That is something that, we're going to look at and we're going to evaluate, and that can actually be used to establish retaliatory conduct against the employee. Again, transferring to undesirable shifts or locations. If somebody's a day shift employee and then is transferred to night shift, that's an example of retaliation against them when it's made, because of and based on their, reporting or complaining about this discrimination. Exclusion from meetings, training, advancement opportunities. So, when they request to go to some seminar that they were permitted to go to for the last 4 years, and then they make this complaint and they're no longer able to attend, that's an example of retaliatory conduct. And then the obvious one is when they're terminated shortly after filing a report or cooperating in an investigation. All right, turning it back over to Mike to talk about business as usual.
So to Reagan's point, kind of following up on Reagan's point regarding, we need to treat these employees who make these complaints the same, not any differently than any other employee. This also goes with the premise that business is as usual. Employees still need to complete their day-to-day tasks. They need to show up to work on time. They still need to do their job. I think we see this in a lot of cases where an employee makes the complaint. They think that they're immune from any adverse employment action. They more or less stop doing their job. One, that's not okay. We need to make sure you're protecting your other employees, that you're treating this employee the same as any other employee. And we need to make sure that the individual is being properly disciplined if necessary. Again, they still need to do their job. For an example, if an employee, if it's an employer's policy that states an employee will be written up if they're more than 30 minutes late, and Jessica, who recently lodged a sexual harassment complaint, is more than 30 minutes late, she should be written up just like any other employee. We just need to be ultra careful that any action that we take after an employee makes one of these complaints or any type of employment type complaint, any action is going to be heavily scrutinized. So you want to make sure that you're treating this individual the same as you would any other employee with or without their complaint. Again, if it's department policy to write somebody up if they're more than 30 minutes late and you're always doing that consistently, that's fine. Make sure you write that employee up. If it's a loose policy where you're usually not writing somebody up, but you're writing this individual up, that's going to be seen as retaliation. So you just want to be careful that you can show why you took the action specifically and that it had nothing to do with the employee's action. And again, documentation is king. Document everything. As Reagan said, these cases usually come about a lot later. So you want to be able to articulate specifically why you took the action that you did. Looking at some examples of duty to report. In this fact pattern, a junior employee, Priya, tells her supervisor, Lieutenant Dawson, in strict confidence that a coworker has been making sexually suggestive comments to her for weeks. She begs Lieutenant Dawson not to say anything because she doesn't want to cause drama. Lieutenant Dawson agrees to keep it between them and takes no further action. 2 months later, Priya formally complains to Human Resources and the city is sued. Again, as we talked about earlier, as a manager, Lieutenant Dawson, once they heard of this complaint, they had a duty to report it immediately, even though Priya didn't want them to. What happened here is not only was the city subject to liability, Lieutenant Dawson can be as well because he failed to take the appropriate actions. So again, it's a duty to immediately report, even if the employee asks you not to. Moving on to an example of supervisory personal liability. In this case, Sergeant Rose, a supervisor in the city's police department, witnessed a male detective repeatedly making sexually charged comments to a female civilian employee during shift briefings over a period of 3 weeks. Sergeant Rose finds it amusing and says nothing. The female employee later files a complaint under ELCRA, naming both the detective and Sergeant Brooks personally. Again, when Sergeant Brooks saw something, even though this employee didn't come and complain to him specifically, once he saw this, he had a duty to act. Whether or not he found it amusing, he shouldn't, but whether the fact he found it amusing or that it didn't bother him, again, it doesn't matter. This female employee or female civilian employee found it to be inappropriate, and that's all that matters. And again, yes, Sergeant Rose can be held personally liable. Moving on to this next piece, this goes in hand with the retaliation component as well. It looks at the fact that an employee who participates in an investigation gives questions, information to the investigator, they also cannot be retaliated against, just as that specific employee cannot. Moving on to the topic of where this specific conduct occurs. Obviously, if we have conduct that occurred on at the company, at City Hall, in the police department, wherever it may be on company property, that's going to be considered the appropriate venue for the sexual harassment. But again, and generally employees are not held liable, or employers are not held liable for actions of their employees when it occurred off work hours or off the job, but that's not always the case. We've got this Hawkins case where there's an employee dispute where the individual eventually set fire to the car of another individual, and then it was brought to the employer's attention. The fact that it was an employee dispute, that the individuals were only connected through their employment, and that this action stemmed from the employee dispute, the court found that the employer still could be held liable when they found out about it and didn't do anything about it. So again, as Reagan said, it could be something where you're attending a conference or a late night meeting with a client, whatever it may be. If you're there because of your employment, that's obviously going to be seen as as part of the employment relationship. And then moving on to the next slide. So obviously what factors we're looking at, again, where the actions occurred, why it allegedly occurred, why the individual was at that location, was it for work, for a conference, client dinner, off-site meeting, how closely connected is the work relationship to that person's duties, what specifically were they doing, were they meeting with a client, were they attending a conference. So it's a really hard balancing of protecting an employee's private interest with the employer, continuing to keep a safe and not sexually harassed workplace. I know we're running a little short on time here. If we can jump ahead to the maintaining adequate policies. So what we've done here with the remainder of these slides is we've gone through some of the hot topics regarding what policies should be in place. Obviously, how do we expect employees, managers to know all of this, know what they need to do? If it's not in writing, we have to have good written policies where our managers can go to and say, okay, an individual reported this to me. Who do I go to next? What does the investigation need to look like? What information do we need to provide? Specifically, as it shows here on the screen, defining what the purposes of this policy is. Again, this is to protect. These written policies are to protect the individual employees, what protections that they have, what they can report. It also protects the managers, the supervisors, gives them specifically what they need to do when information comes in, what discipline they can take, what specifically is defined as how they know what harassment is. It protects them in that sense. It also protects the employer just because it gives the employer the ability to go to later on in the deposition or during discovery. We can say, the employer had this specific policy, their manager followed it to a T. Whether or not this individual was sexually harassed, we did everything that we could. So it puts the supervisor, puts the employer in the best position possible. Jumping ahead here too, just to kind of some of the key takeaways, and then we'll get into a little bit of Q&A before we finish. Obviously, Reagan went through some of the specific areas of law that are important. Need to know and stay up to date on recent decisions, recent updates to the law. As we talked about earlier, there was a recent change in 2023 regarding protected classes. We need to ensure that we know, when those changes come out, how they impact our employees, how they impact our our organizations. Again, create policies of expected behavior. Employees should know exactly how they need to act. Managers should know exactly what their duties are to report, to investigate. Um, Again, ensuring that all employees are aware of their rights and reporting requirements. Leave no questions, no discretion as to what your employees' actions need to be, what the steps are. We've got a lot of good example policies that we can work with you on and share, where it goes through specifically when a report comes in, what immediate actions need to be taken, what short-term actions need to be taken, and then what in the long run needs to be done. It really does, when you take out the discretion, it sets everybody up for success. Again, investigations and remedial actions, making sure that investigations are unbiased and with the best interests of the individuals at heart. It protects the individual making the allegations, protects the individual who's been accused, as well as protecting the employer for potential liability. Again, protecting against retaliation, making sure that when an individual files a complaint, we're not retaliating against them or taking any actions that would be different from our normal business as usual course of business. Again, doing training such as this. We do a lot of training on sexual harassment for different departments. Reagan and I just did one recently for a city. Having people come in to perform this training, making sure that everybody's aware of what the policies are, recent updates in the law, remaining consistent with discipline. And last but not least, and I think most importantly, I cannot express how important it is to document everything. Document. When we get these cases that come in, the best thing that we can do is we meet with the individual in HR or the city manager or whoever it may be, and they've gotten an entire folder of documentation. And we can go through and we can see a picture of the timeline of when the complaint came in, what information was provided, specific statements from the individual, specific counter statements from the individual accused, what steps that were taken, in a detailed timeline, what letters were sent to the individuals, what was documented, what actions were taken, specific references to policies on why the actions were taken. It makes our job so much easier. It makes the liability against the individual supervisor, manager, as well as the department that much easier to defend. So I think we can now kind of turn it over to any questions. I know we covered a lot in the time that we had, but happy to answer any questions anyone has.
Okay, thanks very much, Mike and Reagan. Now is the time for you to enter your questions into our questions queue, which is located on your GoToWebinar platform, the icon at the top right of the page, and a paperclip. So if you could do that, we'll give it a second here to take a look and see if we have any questions bubbling up. I know you did cover quite a bit, so I'm sure people are taking copious notes. I do have one question. I don't know which of you want to answer this one, but with remote work becoming more common, how does the hostile work / sexual harassment analysis apply to conduct that occurs in the digital space?
Yeah, and I can jump in first on that. I think that there's a lot of good that comes from remote work, even a remote seminar like this where we can all get together. Employees can get together with a large group of people who are maybe even in different states. But it does cause a lot of issues because, we're still, even though people are, they may be, sitting on their couch or sitting in their bedroom, they could be wearing pajama pants, even whatever it may be. You're still working, you're still interacting with your employees. I think when people work from home, they let down their guard a little bit because of the atmosphere that they're in. But for purposes of analyzing this under the hostile work environment sexual harassment standards, it's really no different if you're working at home or if you're in a meeting via Zoom at home with your employees, or if you're in a meeting in a boardroom at the office, treat it the same. Any comments made, any actions, you know, I think that that's a clear example of where off-site actions are still attributed to the employer and employees. You know, when you're working from home, you should conduct yourself just in the exact same manner as if you were working in the office together.
Great, thank you for that. Another question's in. This one is a matter of degree on touching. Are you saying that a male supervisor who touches shoulders in a non-sexual way as he talks to employees, both male and female, is considered sexual harassment if the employee is uncomfortable with touch and you talk to the supervisor about not touching employees and it happens again? It's a bit of a habit for this person.
Yeah, and I think where we get to it going closer to sexual harassment is when we have that habit of constant touching, where the individual has been talked with about, and individuals have complained that it's making them feel uncomfortable. If it's a one-off, you know, specific touching of the shoulders, it still could rise to the level of sexual harassment. And again, it goes back to that reasonable person standard. What would a reasonable person in that circumstance think? And so, but I think where the bigger issue comes in is whether it's continuous over a period of time, multiple issues of the individual touching another individual, even after being advised not to do so. Again, that's why we say just don't touch your coworkers. That it's an easier rule to follow than to figure out whether it might impact one employee versus another.
I just want to jump in on that real quick, because I think, you know, without more facts, just hearing the question, that is an interesting issue if it's happening where he's touching both males and females, because Elker says that it has to be because of their sex. Now, obviously, you know, physical touchings are you know, hard to defend, but when we have that fact, that presents something that's very interesting. You know, so obviously, you know, it might be worth dispersing your sexual harassment policy and maybe having a follow-up conversation again with that employee about, you know, no touching in the workplace.
Great. I have one more question in the queue, so last call for questions if you want to ask one. The last question I have, I know we're right on time here, so how can supervisors balance the duty to report with maintaining trust among employees for open dialogue?
Yeah, I can jump in first on that. I think it's challenging. And I think it really is dependent on each individual agency. I mean, on one hand, you want your employees to feel comfortable coming to you with these issues. You want your you to have that open door policy that we discussed. But also there are those mandatory reporting requirements. So I guess my recommendation is, and I think this goes back to having detailed policies that really take away any discretion from the managers in the sense of reporting and what they need to do specifically. I mean, I think that then managers and supervisors, they can kind of let the policy be the bad guy and say, you know, unfortunately, this is exactly what the policy says I need to do. You know, you did tell me this. I appreciate, you know, we'll do everything we can to, you know, make this process as smooth as possible. And, you know, whether or not you can keep it, some of it confidential to the extent you can, you should. But again, make the policy the bad guy and kind of take away some of the discretion from the manager. So then it's not as much on them whether they want to take certain actions. It's required.
Great, thank you for that. Okay, I don't see any other questions in the queue. We are at time, so I'm going to kind of jump in here and wrap things up for everybody. Again, thanks for attending today. As a reminder, you're going to get a little pop-up survey when this program concludes. We'd really appreciate your feedback and any ideas you have for future topics. We take those to heart, and so that's important to us. So please complete that survey for us. The other thing I want to just remind everybody of, you're all going to get CE credit certificates. If you don't need those for HR, CI, or SHRM, you could just disregard that. It would be meaningless for you, but it's a lot more of a smooth process for us to issue them out and just have you delete them if they're not applicable to you. The presentation for today, again, is being recorded. We're going to post it to our event page on our website, punkacooney.com. Right now on your screen, you also see a QR code. It'll be in your materials as well. If you want to check out our YouTube channel, we have a ton of different employment related topics covered in our various webinars over the years. So please take advantage of that library, which of course is available to you 24/7 at your leisure. And feel free to share that with your colleagues as well. The other thing I'd like to do before we finish is just give a quick plug to our Sophisticated Employer blog. If you're not familiar with it, go to our website under Insights. You can find our blogs. Sophisticated Employer is one of those. And you can see highlighted in yellow there that you can quickly email or sign up by email to receive alerts when new content is presented on the blog. A lot of great topics. Again, years of content there for you to peruse. And we'd love to have you and your colleagues sign up for that so we keep you up to date on all the latest issues going on in employment law. So with that, on behalf of Michael and Reagan, I want to thank everybody for attending today's program. Hopefully you got value out of it. We're available and here for you, so you can certainly reach out to them directly if needed. And until next time, thank you and have a great rest of your day.